call Chris Hipkins.
Thank you very much, Mr Chairman. Normally in this part of a committee stage debate we would have the opportunity to reflect on comments that submitters to Select Committee had made and so on, and many of the things that we would reflect on at this point in proceedings would be whether the bill is going to meet the stated purpose, whether there were other options that weren't considered that should have been, and whether in fact there are parts of the bill that don't address some of the issues which it purports to address, and whether there are in fact gaps in the legislation. Of course, our ability to do that comprehensively and thoroughly is somewhat constrained in this instance because the bill hasn't been to a Select Committee. It's had its first and second readings already today, and it will probably be passed into law, if not tonight, then certainly at some point tomorrow. And therefore, we have to, I guess at what people might have said when they were submitting and try and identify the gaps in the legislation within a very short and constrained period of time. And the first thing that leaps out at me, Mr Chairman, in reading through the legislation is one of the big gaps for me. And that is, if the purpose of this bill is to identify people who would be at risk of reoffending when they are deported to New Zealand, the first question that I have is not about whether we should be fingerprinting them and all of those things which the bill adequately deals with. It's about what does this bill do about reintegration and support within the community for people who have offended whilst in Australia, for people whose base is primarily in Australia or another country, because of course this bill is not specific only to Australia, and there is nothing in the bill that deals to that. And of course reintegration is one of the most important factors in preventing reoffending. Everybody who works within the correction system will say that if a prisoner who has recently been released, and bear in mind the types of offenders that we're talking about in this legislation have only been released within the last 6 months or so, anybody who has been released, the amount of support they get within the community during those critical first few months is actually a big factor in whether or not they are likely to go on and reoffend, and there is very little in the bill that deals with that issue. The second thing that I want to raise about that, and the second part of the bill that leapt out at me, was the fact that this requires the Department of Corrections to trigger things in the first place. So there's nothing automatic about this. This requires the Department of Corrections to be on top of things, and I have to say I have some real concerns given the recent performance of the Department of Corrections as to whether or not they are actually up to the job of doing that. We've seen huge issues and huge concerns raised about the performance of the Department of Corrections, and yet we are now placing this enormous emphasis on them being the agency that would have to instigate any of these things from taking place, and that concerns me greatly. So we come back to the basic question, which is why are we here? What are we trying to achieve, and will this bill actually deliver on it? Our priority is, and I'm sure actually this is a shared priority across all of the Parliament, keeping New Zealanders safe. Keeping New Zealanders safe and making sure that we are adequately monitoring and supporting people who have previously been sentenced to a term of imprisonment who are released into the community. And we should not approach that differently if they have been released from a term of imprisonment in a different country to the way we would approach it if they had been released in New Zealand. So that's a principle which I think we all support. The question is whether in fact this bill adequately addresses that. There are also questions that I have around the fairness of the way this legislation is being approached, and the fairness of the way some of the people who find themselves subject to this might be treated. I've got questions about why the 6-month provision applies in the way that it does. So as I said a moment ago, this applies to people who have been released from prison within the last 6 months. What if it was 7 months? What if it was a serious offence that they were released from only 7 months ago? How does the 6 months time frame get arrived at? And that's something that I'd very much like to hear further feedback on. The purpose clause in clause 3, which I want to turn my attention to, makes it clear that these provisions only apply to someone who is returning to New Zealand following a prison sentence of more than 1 year in an overseas jurisdiction. And I think that this is something that people at home would maybe get a little confused by, given some of the recent rhetoric around that. So yes, This bill would, Mr Chair,
Chris Hipkins.
this bill would cover rapists and murderers, absolutely, but it is also going to cover a number of offenders who are much, much lower down the scale of offending. It can contain some that you could even say would be deemed to be petty crimes, although I mean the word petty crime is something that I'm hesitant to use because all crime is a crime at the end of the day. But these are people, shoplifting for example in some areas would have a prison sentence of more than 1 year, so someone could be deported back to New Zealand for shoplifting for example, and they would fall within this category. There are probably some vehicular offences that may end up in this category as well. And I think, we should consider all of the range of offences that might be covered by this legislation and not simply say that the only people that are going to be covered by this are rapists, murderers, child sex offenders and so on. That's not the case. It is going to cover quite a spectrum of people, and the response to the different levels of offending needs to be different. And again, there is very scarce detail from the government in the supporting material supplied around this bill for how that response will be different depending on the nature of the offending that has taken place. So I think that this bill, and we're only on part one now, and I want to get into the substance of some of my wider concerns when we get to part two, which contains, I think, the operative clauses of this. But I do want to put on record my general concern about the gaps in the legislation, because simply doing the things, collecting the information, bringing someone under the purview of the Department of Corrections actually really is just a fraction of the situation. I am far more interested in what is the government going to do to support reintegration. If we're looking at people who have been living overseas for a long period of time, they may have no roots in New Zealand whatsoever, no connection with the communities that they find themselves into. They would be isolated, and in fact, fingerprinting them, putting them even under supervision, isn't going to change that unless they are supported. They're still going to be just as likely to reoffend, even if they've had all their fingerprints taken, if they're being supervised, still just as likely to reoffend if they don't have the adequate support in place. And I don't have any satisfaction or any evidence to suggest that the government are truly prepared for that and truly have a plan in place for how to deal with that. So while the Labour Party is certainly supporting this legislation through, because we support the intent of the legislation, which is to keep New Zealanders safe, let's not overlook the fact that this legislation hasn't had the scrutiny that it deserves and should in fact be more thoroughly examined. And so the final point that I want to make in this, my first contribution to this debate, and I hope to make many, many more, is I hope that that this legislation will be re-examined in relatively short order. Whilst I can understand why the government want to progress this legislation with some urgency now, because they haven't dealt with the issue adequately up until now. They've known about this for a year and it's taken them that long to bring it to the House, and therefore we have no choice but to progress it under urgency now. I hope that won't preclude it actually having a more thorough examination further down the track. So I hope that the House will be back reconsidering these matters with proper public scrutiny, including a full select committee hearing, so that we can actually make sure that we are doing the right thing and we're not just putting in place a knee-jerk reaction that won't do what it purports to do.
The Honourable Phil Goff.